I believe that Sue Nickerson and Chip Bishop are here from the Alliance to Protect Nantucket Sound and would like to give us some information. Welcome, Sue.
Thank you, Madam Speaker. I guess Chip is going to stay in the back row there.
Well, if you insist.
Thank you very much for the opportunity to come before you today. I apologize for having a little bit of a cold here. I will only take a brief amount of your time. I know you need to move on to other things soon. First, I just wanted to, there's two things I'd like to talk about today, but first I wanted to thank the Assembly for your involvement and staying engaged with issues around the Cape Wind proposal for the past 4 or 5 years. And my hope is that there will be a point in the future after the draft environmental impact statement comes out that I might be able to return and give you some more detailed perspective on how we're viewing the whole review at this point after that report comes out. But for today, I'd like to just briefly describe for you two things. One, or present to you two different issues. One having to do with the status of the draft environmental impact statement, and the second, not related to that, but certainly very relevant to all of us here on the Cape, the decision of Cape Wind to appeal to the Energy Facilities Siting Board the denial of the Cape Cod Commission on the development of regional impact permit. So just very briefly, in terms of the draft environmental impact statement, the reason that I came to see you today is that we are expecting the federal government, namely the Minerals Management Service, to release their version of the Cape Wind draft environmental impact statement either late this month or sometime in January. It's, at this point, we're hearing it's probably going to be January. This is different than the Army Corps report, which you know that came out in 2004. It generated a lot of public comment, a lot of time and effort, particularly on the part of the Assembly, spent analyzing that, commenting on that. That basically was shelved. I believe there were some components of that that were useful in the new version of the DEIS that's going to be released, but basically, Minerals Management Service started from scratch. So we can expect to see release of a major document, probably, again, the size of 4 bags of sugar. That's how we described it before, 4 or 5 pound bags of sugar, probably about the same size. And maybe a 60, hopefully a 90-day period for public comments. And during that public comment period, it's quite likely that the same procedures will be followed with a hearing here on Cape Cod. The last one was at the Mattokees Middle School, a hearing on Martha's Vineyard, a hearing on Nantucket, and probably a hearing in Boston. And how those unfold, last time you remember it was a marathon. They were 3 in 1 week and then 1 in the following week. Hopefully they'll have a little more mercy on us this time. But they will probably happen in rapid succession, somewhere in the middle of the comment period, and then the close of the comment period, within 60 to 90 days total. So we really just wanted to kind of put everybody here on notice that this really is going to be the last opportunity that we here on the Cape and Islands have to tell the federal government what our views are on the Cape Wind project. This is going to be the last time, I believe, that we will have the opportunity in terms of a public hearing to go before a federal agency that's making the actual permit decision on the Cape Wind project. And so it's a critical point in time for this particular issue on the Cape. So I'm happy to answer any questions. There aren't any specifics about the release date, really.
Okay, thank you.
Should I do the second item first?
Ahead.
Okay.
Yes.
Okay. The other thing on my mind today is the concern that I'm here to expressed to you from the Alliance to Protect Nantucket Sound, but also personally with regard to what's happened with the appeal of the Cape Cod Commission decision denying Cape Wind its development of regional impact permit. Cape Wind, as you know, appealed that to the Energy Facilities Siting Board, basically breaking open new ground in terms of a proper route of appeal. And for those of you that are students of the Cape Cod Commission Act, you know that the routes of appeal established by that act were either to Superior Court or Land Court, not the Energy Facilities Siting Board. So this is really a precedent-setting case, which is going to affect very broadly the powers of the Cape Cod Commission, as well as probably the Martha's Vineyard Commission, in terms of what the commission can do with regard to regulating energy-related projects. So not only are we concerned about that from the Alliance's perspective, obviously with regard to Cape Wind, but we have a larger concern, and I guess I'm speaking personally now, about maintaining the powers of the Cape Cod Commission with regard to all projects that meet the thresholds of a development of regional impact. So that is definitely a concern. And then the other component of that appeal, not only the questionable route that was selected, but also the nature of that appeal, which seeks to bundle every single state, regional, Cape Cod Commission, and local permit in one super permit that they're calling a composite permit. But basically, they're seeking at this point to do a one-stop shop for every other remaining permit. And so they won't have to go to the towns, they won't have to come back to the Cape Cod Commission, and apparently they won't have to go through the different agencies, that some of which are already processing Cape Wind permits. For example, the Division of Fisheries and Wildlife issued a no-take permit on endangered species. That's very, very concerning. It's obviously an end run around local process, a trampling of local process. And so I speak to you today not only representing the concerns of the Alliance, but myself speaking as someone who's been involved with these issues, as many of you have for years and years, and the fact that this is just a really, really horrible precedent, and one that I'm hoping the Assembly will pay some pretty specific attention to, and perhaps express an opinion to the state and to not only the EFSB, but to the Patrick administration as a whole. So with that, if there are any questions, I'm happy to try and answer them. I don't know if Paul's still here. I guess he left.
No, he left, but...
yeah, I don't know what the commission is going to do with regard to the EFSB.
I'm sorry that he left. That would be interesting to hear. Questions? Tom?
I would agree with you on the end run around local control. It does sound like this was a project that started out where they were looking for local input and trying to involve the localities, and now that the method they're following, does not fit with the way I would like to see it proceed. But my question was, I'm wondering how might the Assembly weigh in on the appeal? Is there anything specific that you're thinking we might have an impact on?
Right, and here I'm getting into territory that I don't know a lot about, but there will be a hearing process. Secretary Bowles certified that this application could now be made to the Energy Facilities Siting Board, so Cape Wind will file that, and if I had to guess when, I would guess either Christmas Eve or New Year's Eve is when they're going to file it. But they will file it, and then that will begin a hearing process, so certainly there will be opportunities, and again, it has to do, in terms of who can comment, it has to do with your status, and that's really more of a legal question. I think that it's probably perfectly within your realm of operation to just write a simple letter to the Energy Facility Siting Board or to the governor expressing what you think about the turn of events here. And I don't want to, cross into too many areas that I don't know a lot about, but maybe the commission has some guidance on that based on what they're planning to do, which is, I believe, unknown at this point.
But, are you saying that through this hearing process, there may only be certain eligible groups or individuals that have a certain status to testify?
Right, yeah. I don't know the exact legal terminology, but you have to have certain party status to be able to participate in proceedings. But it may be that the Assembly could be a party because of your relationship with the Cape Cod Commission.
And I assume you'll know who are those eligible folks. You can let us know if there is a role that some of us might want to play on.
Absolutely, yeah. I think that will become clear once Cape Wind actually files for that permit. But I'd be happy to get back with you on when that happens, what the options are.
Right.
Several years ago, I know we passed a resolution just asking for a thorough review. I think that was the language. Is it something like that? We must have it somewhere. I don't know if you have it, but we didn't get into a statement of support or non-support, but just that we supported a thorough review. So perhaps, if somebody wanted, we could draft something that might address some of your concerns, and that might be helpful.
Are you speaking now, Ray, with regard to the DEIS, or are you talking now with the EFSB?
Well,
just generally.
Yes or no?
Or you could draft something and we could go from there, too.
I'd be happy to provide some thoughts on that if it would be helpful.
Julie?
Well, I do feel that the question of the commission's legal power here and what the right of place for an appeal is very important, and we need to immediately get in touch with the commission, I think, to find out what their plan is. And I, for one, would hope that they would object to something that seemed to go against what the law, what their charter says. I would be very upset about that. I wondered I've sort of forgotten, how did the federal management people get involved? Obviously, it's not like timberland or mining land where there already are regulations in place, although I know at one time the Interior Department was considering drafting regulations, but I presume there are no regulations, so how did they get to be people to get involved?
Yeah, that's really an excellent question, Julie, because it speaks to the whole process issue. But as you recall, the first stop for Cape Wind was the Army Corps of Engineers, and mainly because of the hue and cry that arose from the Cape and Islands and a number of different quarters about the Army Corps not really having the ability and the expertise to take on a whole new national energy program, namely offshore wind. There was a provision in the Energy Policy Act of 2005 that was passed by Congress that directed the Department of the Interior through the Minerals Management Service to create an offshore renewable energy regulatory program. And so now that is in process, but one of the issues that we are working, we really are very concerned about and working with our contacts in Washington is that the regulations that you're speaking of, which are critical to guide all future development on the Outer Continental Shelf, have not been drafted yet, and yet Cape Wind is about to be reviewed in the absence of these regulations. So that is a serious process flaw that we are complaining loudly about right now. But anyway, assuming that the Cape Wind comes out, and Minerals Management Service is looking at that as part of their new assignment for reviewing all offshore renewable energy projects, whether it's wind, wave, tidal, what have you.
Any other questions? Fred?
Thank you, Madam Chairman. So I've always wondered why Gordon and Cape Wind would not look at a phased project. And it has always seemed to me, when you look at what is going on in Europe and how their offshore projects have happened, it has been smaller projects and in those particular waters, and then more turbines have been added into those waters after some measure of what the effects are. And it's always seemed to me to be a problem of size and scale, the 130 units being put in there all at one time, rather than putting in a smaller number and being able to see what the impacts are before you then put the second. Has that, I know the Cape Cod Commission a couple of years ago in their response talked about that. They talked about smaller turbines mixed with larger ones. They talked about a variety of pieces, all of which I never saw any either response from the federal government or Ian Bowles to the Cape Cod Commission's ideas about what could be done.
Right. That's, again, another very interesting angle to this. In Europe, the reason that they've been able to do these phased projects is because there is a very strong public-private partnership where the funding is available so that it's not as risky for the developer to do a small-scale project. And in this case, this obviously is the first one in this country, but the developer is assuming 100% of the risk. Therefore, as I understand it, and I have asked Jim Gordon that very question, he's basically looking at Europe as his pilot project, and that in order to make it economically, meet whatever his economic model is, which we don't know what it is, but in order to make it work, it has to be this big right out of the gate. That's been kind of his bottom line. So then the question in our minds has really become, well, it's really, it's the right idea in the wrong place. And what about a location in deeper water, which is where Europe is headed right now, very much so. And so our hope is that when the Minerals Management Service report comes out, that they will have a significant evaluation of deeper water alternatives outside of Nantucket Sound, because that's where the technology is headed. And that could be something that is a win-win scenario.
Sheila?
I just wanted to make one thing clear in my mind. You're saying that in this process of appeal that they're pursuing at this point, and and then opening it up to public hearing again, that it's definite that they will be choosing, that there'll only be certain invitations, in a sense? Are people allowed to speak at these groups? Or that's what you're fearing from what you're hearing out there? I mean, that's a
I don't know the process well enough, really, Sheila, to tell you what, I believe, based on the other hearings before this same body, Energy Facility Setting Board, there's sort of levels of participation, and there's parties to the issue, then there's interveners, then there's amicus groups, and then there's the general public, and I don't know, in terms of status and participation, how it all works. So that really, I'm sorry, I can't answer that. That would be a question for your
But that is,
counsel.
in general, how it does work, and that's what we're to be looking for.
Right.
Who's on that
Yeah,
list.
who's on the list, yeah.
Okay, great, thank you.
Fine. Any other questions? Okay, thank you both very much.
Thank you, Madam
And if you have, Chip, did you have anything you wanted to
I
add?
only wanted to add to the point that people who are viewing this procedure on television today keep abreast of the timing of these public hearings. They are likely to occur in late winter, possibly even early spring, sooner rather than later. And this will be a very, very important opportunity for people to be heard and to come out, undoubtedly on a cold and dark evening, but to make the effort to be heard, because the feds are coming here to listen, and voices need to be heard. So people should stay abreast of the information in the paper and on various websites, and be prepared to be heard.
Fine.
Very important.
Good, okay. Thank you very much.
you, Madam Speaker.
And we'll look into what we can do.
Wonderful.
Okay?
Great.
Thank you very much for coming. Wish you both a Merry Christmas. Thank you.